Thank you, my lady and my lords, and my lords. My lord, the petition that is before court is the one dated 7th of June, 2021. My lord, this petition has been previously has been the subject of many amendments. My lord, it's important to mention these amendments because of the legal questions which were addressed by Mr. Issa and Ben Nasir regarding the competence of the petition. The petition as originally filed in court, it was filed on 26th April 2021. My lord, it was subsequently amended on 29th April and 17th April, and also on 20th, my lord, 17th May and 20th May. My lord, you will note that from the petition which is dated 29th April 2021, that petition is supported by a supporting affidavit, my lord, of the third petitioner, a gentleman known as, my lord, the first petitioner, a gentleman known as Aden Ibrahim Muhammad. So, my lord, the legal question is that it is not correct to say that the petition which is before court. My lord, it is the one of 29th of April. It is supported by the affidavit of Aden Ibrahim Muhammad. My lord, this affidavit is a complete affidavit. It's the one shown on 29th of April 2021. And you can see it was drawn by the firm of Ndegu and Ndegu Advocates. So the legal question which this court is supposed to determine, because of the issues raised by Senior Counsel Ben Nasir under Issa, is whether this petition is supported by an affidavit, a supporting affidavit. So the legal question is, when you seek leave of the court and you amend a petition, and you don't amend a supporting affidavit to that petition, does it render the amended petition incompetent? When as a party you don't need to amend the supporting affidavit, you only need to amend the petition. Does it render it incompetent? I believe that is a fundamental legal question which this court can determine. Because, my lord and my lady, if you look at the Mutunga rules, the Mutunga rules at rule number 11 provides that a petition may be supported. It doesn't say that a petition shall be supported by an affidavit. It doesn't say it must be supported by an affidavit. So in any event, even if we were to say that the further amended petition is not supported by an affidavit, the one of 7th of June, the rules cure that factual issue. So the bottom line is that that petition is supported by an affidavit. This Honorable Court has not struck out any of the amended petition. The amendment is for purposes of bringing currency to the proceedings. And you can amend the petition without amending the supporting affidavit. So I believe that puts the response by Ben Nasir at paragraph 3 of the supporting affidavit of Honorable Abdullahi Isaac. It puts that issue to rest. The supporting affidavit, the replying affidavit of Honorable Abdullahi Isaac of 14th of December 2021, it puts that question to rest. Secondly, my lord and my lady, this petition is predicated on documents which have been annexed by all the respondents. So there is some kind of an admission in terms of the factual context in this matter. My lord, my lady, for example, the supporting affidavit of Honorable Abdullahi Isaac, the one of 14th December 2021, contains all the documents, my lady, my lord, all the documents which are in the supporting affidavit of Aden Ibrahim Mohammed.
Which affidavit has the documents?
The supporting affidavit of Honorable Abdullahi Isaac, filed by the law firm of Ahmed Nasir Abdullahi, LLP, the one of 14th December 2021. It has all the documentation that the petition contains exist. Secondly, the supporting affidavit of Jeremy Nyegenye, the replying affidavit of Jeremy Nyegenye, the clerk of the Senate, the one dated 14th July 2021, which was filed after they have been served with an amended petition, contains all the annexures and additional annexures which we are going to make reference to, including the proceedings that happened in the Senate during the impeachment process. And my lord, the same applies to the replies filed by Isa on behalf of the first interested party, who is now a respondent as per the order of the court. The reply of Honorable Ahmed Ali Mukhtar. So as we speak, there is a meeting of minds regarding what transpired. There is a meeting of minds regarding what transpired in terms of the facts, which I want to go to next, as I illustrate the... Sorry?
We have not filed an affidavit in petition 9 or petition 17. We have filed a response under the rules. So Mr. Wanyama should be clear about what he's referring to.
Well, I'm referring to the response which has been filed by Mr. Issa, where the factual contestations are not denied. He adduces very important facts in his response, which confirms the factual position in our petition and the supporting affidavit of 29th April. So my submission is that, as it were, there is no factual dispute between the parties. The dispute between the parties is a legal one. Principally, the dominant dispute between the parties is a fundamental legal dispute which I want to address next. My lady, my lord, the substratum of this particular complaint relates to the impeachment of Ambassador Abdi Ahmed Mohammed, which was initiated by the County Assembly sometimes in April 2021. The factual occurrence regarding that impeachment has been described from paragraph 15 to paragraph 16 of the petition, the amended petition, which is before court for hearing, and subsequently from paragraph 17 all the way to paragraph 56 of the amended petition. Now, the principal complaint by the petitioners is that on 26 April 2021, this Honorable Court issued conservatory orders staying the impeachment process at the County Assembly. Principally, the conservatory order suspended the notice of impeachment dated 19th April 2021 and the notice of motion dated 19th April 2021 and the notification to that effect dated 20th April 2021. That issue was suspended by a valid court order. And the reasons which the applicants were able to persuade the court is that there were certain fundamental breaches of the Constitution and law regarding to the impeachment process, prompting the court to exercise its mandate and jurisdiction to conserve the status quo, pending the hearing of that particular question. My Lord, nonetheless, that court order was disobeyed by the County Assembly. And my lady, my lord, I'll be coming to that issue when I respond to the question whether the Honorable Court was entitled to issue the conservatory orders. So that order was served. I need to emphasize the order was served on 27th of April 2021 to the County Assembly.
On which date?
27th of April 2021. The petitioner's counsels
I have an objection to make, and I think the objection has to go on record. Where is the evidence of service in any of the petitions? You can't just be making submissions when there's no factual basis for any of these submissions. And I said this will come to arise. Where is Mr. Wanyama referring to service? Where's the affidavit of service in any of the petitions?
my lord, I thought these are issues which he needs to raise a reply on.
No, I cannot do that because I have a right to object at the earliest moment. Where is that evidence on record? Ask him to point the court to the evidence and then you can make the submission. We can't do this as if we're in a baraza.
My lady, my lord, I am yet to complete my submissions because in the end of on that submission, I'm going to make an important remark regarding admission of service. So my senior colleague, who is a close friend of mine and has led me in very many impeachment cases, need to wait until I complete my submissions, both at with respect to service at the County Assembly and also service at the Senate. It's a fundamental question. Where there's an admission of service and where they have made a ruling on that issue that they are not bound by the court order, I will be able to complete my submissions. Then he can be able to reply. Let him not be unnecessarily apprehensive when the seat is getting hot.
Apprehensive. I just don't want and that is an objection that is fundamental. An advocate cannot give the bar.
Mr. Isa, I've recorded you to say to ask where is the evidence of service being alluded to by Mr. Wanyama. So I think Mr. Wanyama, you just take the next go and tell us answer to that question so that we move.
My lord, what I'm submitting on is that service was admitted. That is going to be my next remark. Admitted both at the Senate and at the County Assembly. So I don't need to point out where the affidavit of service is, where service has been admitted. If service has not been admitted, then it becomes a completely different issue.
It's okay, Mr. Wanyama. I think it's easier. It's not a quarrel between you and Mr. Isa. Just lead us to say where's the admission. Then we move on.
Exactly. That's what I was going to next.
Go on, Wanyama. You're muted.
And I will appreciate if they don't interrupt my submission. If there are issues, burning issues, they should raise, because it interferes with the flow, with the with the flow of my submissions. So I will come back to the issue of service when I wind up on that particular limb, because I wanted to combine the issue of service at the county assembly and at the Senate and on the admission which was made. But what I want to point out is that from the petition before court,
Mr. Wanyama, I've given directions that your colleague has raised an objection. Let's deal with the objection and move on. He has raised an objection which you have recorded. Please deal with it. Answer to the objection.
I need to point out, because my lord, it will be unfair to me if you don't allow me to complete my submissions, but let me just go to the affidavit of Honorable Abdullahi Isaac. My lord, the affidavit of Honorable Abdullahi Isaac, a member of the county assembly, the one filed by Mr. Ben Nasser, the one of 14th December 2021. 2021, because my lord, I was going to come to that issue. But now, if you look at that affidavit, and this is the member of the county assembly. Look at paragraph 24. Paragraph 24 of that affidavit, where there is an express, clear, and unequivocal admission, where they said that the issue of service was raised as a preliminary issue before the special committee in the Senate. And the special committee observed that they face similar difficulties before when they get court orders. And they are not concerned on the validity of the proceedings before another legislative body. Whether there is an injunction or not, they are not concerned about that. And then they say their mandate is strictly on whether the matter has been substantiated or not. And that is where we hit the opposite side on this particular matter. That is where we hit the opposite side. So my submission is that that issue was raised. They admitted there was service. They admitted, this is the county assembly, they admitted there was service of the court orders. But nonetheless, they proceeded to hear the matter. So that is really my response, my lord, if I can proceed to submit on the complete legal question now.
My lord, and I think that confirms our objection that he's talking about the Senate and he was submitting about the county assembly on the 27th. We have raised, my lord, when you return and look at paragraph 8I of our response, we specifically avert that no orders were ever served on the county assembly. And we say without
Mr. Issa, let's move on. You will, whatever you're saying now can be said in your response, eh? So that as he says, we do not interrupt his line of submissions, eh?
I stand guided, my lady, but what I'm saying is that Mr. Wanyama confine himself to matters of fact that are on record, not from the bar, because what he's submitting is from the bar, and that's where the objection is coming from.
Proceed, Mr. Wanyama.
So the question of service of court orders, both at the county assembly and at the Senate, is hotly contested in this matter. So in the light of this express, clear, and unequivocal admission on service by a member of the county assembly, especially a member who participated in the proceedings completely, because these proceedings don't end at the county assembly. They also go to the Senate. Because subsequently, this honorable court, when the impeachment orders, when the impeachment proceedings continued, an application was made to join His Excellency the Governor of Wajir County, the Deputy Governor of Wajir County, Ahmed Ali Mukhtar, the Chief Registrar of the Judiciary, the Assumption to Office of Governor Committee, the application was made to adjoin them as parties, for the reason that they proceeded, when this issue was raised before the Senate, the issue of the conservatory orders, as admitted by my colleague, when admitted by in that particular affidavit, and I urge the court to look at the Hansard which are contained in the supporting affidavit, in the replying affidavit of Jeremy Nyagenye. That issue was raised as a preliminary issue, but nonetheless, the committee of the Senate proceeded to hear the matter. And on 18th of May 2021, this Honorable Court issued further conservatory orders. Further conservatory orders which were equally served. Secondly, and this is why I wanted my colleagues to allow me to finish my submissions, the issue of service of the court order is not a major issue yet. It is not an interlocutory issue now. This court is dealing with a substantive petition. It was an interlocutory issue earlier, but it is now a substantive issue. Because the legal position is, because of the proceedings which transpired on 17th of July of May 2021, which proceedings have been admitted in the affidavit of Honorable Abdullahi Isaac of 14th of December, where they say that after the impeachment confirmation by the Senate on 17th May 2021, there was a Gazette notice which was issued, which we admit. The Gazette notice is in the annexure number 1 in that supporting affidavit, dated 17th of May 2021. The certificate of inauguration of the Deputy Governor, dated 18th May 2021. And principally, there's a confirmation that the Deputy Governor was sworn in as Governor. The swearing in happened on 18th of May 2021. Our principal complaint is that the swearing in was done in a hurry, contrary to the provisions of the Assumption to Office Act of 2017. They did the swearing in a hurry, principally because they wanted to violate the court order, which they knew had been issued. Now, the fundamental question here, my lady and my lord, is knowledge of a court order. As we speak, they know there is a court order which was issued earlier against the county assembly, and subsequently on 18th of May 2021 by the Honorable Justice P.J. Otieno. Now the question is, these orders are valid to date. On the opposite side are certain illegal acts which have been done consequent to that particular court order. Isn't that not a ground for nullification of all these consequential acts which were done contrary to that court order? My submission is that yes. So they can say that the court orders were not served. They can say that, and they can go around on all that question. But do the proceedings which we are complaining about, were they made in violation of the court order or not? The answer lies, and I want to cite a precedent: Martin Nyaga Wambora versus the Speaker of the Senate and others, petition number 3 of 2014, which I was fortunate to argue this petition for the petitioners together with my colleague Issa and Abenasir. We were led by Paul Mwite, Senior Counsel. Benassi Senior Counsel was one of the lawyers who assisted us at great length in arguing this petition. If you look at page, in our list of authorities, if you look at page 72, which is at paragraph, if you look at paragraph 315 of the authority, and specifically the relief which the court made, because I don't want to waste a lot of time, the relief where the court says in paragraph 316 that we declare that the proceedings, resolution, and consequential gazette notice, actions and any communication with regard to the removal of the first petitioner from Embu County Assembly and the Senate were held in violation and in disregard of court orders and were therefore null and void. So the principal question which I submit is that, knowing that these orders are still valid to date, can this court sustain these proceedings which the respondents now know are in total violation of the court order? They know very well these are in violation of court. There's no way you can sustain these resolutions. And that's why we are saying that you allow the impeachment proceedings. You allow the petition before court. The swearing in we submit was done in a hurry. The impeachment was done on 18th, and the swearing in was done on 19th. Can you imagine that, my lady and my lord? Within a span, midnight, everything was done at midnight. Within a short span, the following day, everything was put in place for the swearing in. We submit this is contrary to the Assumption to Office Act, specifically Section 16 of the Assumption to Office Act, as read with Section 11. Section 11, I was doing my calculation, says, the county governor shall be sworn in office on the first Thursday after the 10th day of the declaration of the final results. While Section 16 says that this provision also applies with modifications when a deputy governor assumes office when there's a vacancy. So if you look at the calculation of this, impeachment was done on 17th, the confirmation of the impeachment. The swearing in was done on 18th. Legally, the swearing in from 18th of May, the swearing, you count 10 days. So the swearing in was supposed to have been done the first Thursday after 10 days. In this case, it was supposed to be done on 3rd of June, that Thursday, 3rd of June 2021. If you interpret the provisions of the Assumption to Office Act, Section 11 and Section 16. So you can see the swearing in was done in a hurry. And there is a reason why the Assumption to Office provides for these elaborate procedures to be made before a governor is sworn into office. So the only reason why they were in a hurry to swear the deputy governor to office is because they wanted to beat the court orders which were issued on 18th, which they were aware of, which these court orders remain valid to date. So you can see from that angle of the submissions, apart from the earlier angle, then this court has enough grounds to set aside the consequential proceedings which were made pursuant to the breach of the court orders. Now let me address the fundamental question which is at the heart of ISA's application as I proceed. It has been submitted, it has been posited by ISA that the High Court does not have jurisdiction to grant conservatory orders because of the principle of separation of powers, which provide that county assemblies, when they are properly seized of a matter, the Honorable Court is supposed to exercise restraint and not proceed to injunct the county assembly proceedings and the Senate proceedings. That is the substratum of ISA's application for setting aside of the conservatory orders which were issued by this court earlier on as submitted. So this is my response. One, I was interrupted. So I asked the court to consider.
It is true there was a back and forth with Mr. Issa. Your 90 minutes are over now. We allow some 5 minutes more.
That's all right. I'll make my submissions. Unless Professor Agenda wants to donate 10 more minutes. Maybe Professor Agenda, you can be gracious enough. So,
yes, Kalonzo, I don't mind. I can give Mr. Wanyama some 5 minutes.
Thank you. Thank you, Professor. I'll straight away go to the meat. Mr. Issa submitted that this court lacks jurisdiction to grant conservatory orders based on the Supreme Court decision in petition number 32 of 2014, which I want to distinguish. No, my submission is that nowhere in this Supreme Court authority has the powers of the court to give interim orders taken away. What the Honorable Supreme Court is saying at paragraph 83 is that the High Court is supposed to exercise caution and restraint, but it doesn't take away the High Court's primary jurisdiction, especially if there is breach and blatant disregard of the Constitution and law, like in this case. Secondly, this Supreme Court authority, while it's a guidance on the exercise of the discretionary powers of the court, if you look at paragraph 84, it says from the facts of this Wambora case, there's no blanket injunction on the High Court. It says from the facts of this case, that the implication is that the Honorable Judge, when faced with the petition, is supposed to determine that petition based on the situation-specific facts in that particular matter. Secondly, the same Supreme Court in paragraph 95 is saying, in our understanding that the exceptional circumstance of this case, in this case, the Wambora case. So it proceeded then to say that because this matter was properly before the County Assembly, then the Honorable County Assembly was in its right power, in its correct powers to determine it, and it set aside the interim orders. The Supreme Court has never said that when the County Assembly is in breach of the Constitution at that very early stage, interim orders cannot be granted, because that is not the interpretation which I get from this particular authority. The Honorable Court is simply being told to exercise absolute caution, and where facts commend itself, then the Honorable Court can grant those interim orders. Like in this matter, the fundamental fact which I was looking at the responses, and they have not even adduced that evidence, because ours, we have submitted that there was no public participation. Public participation is an important prerequisite in the impeachment process. There's no newspaper advertisement showing that they did public participation. Secondly, on the question of public participation, they are saying that we notified people. They notified who? To go to the office of the county clerk and get details of the impeachment. My Lord, the jurisprudence on public participation is that we're supposed to be meaningful and qualitative. The election of a governor is not a simple matter. The removal from office is also not a simple matter. And therefore, it makes juridical sense that the people must be involved in the impeachment process by giving their input based on the Court of Appeal decision. The Court of Appeal decision, Nyeri Civil Appeal number 21 of 2014, and Nyeri Civil Appeal number 194 of 2014, the Martin Wambora case, where the Court of Appeal set aside the impeachment on only one additional ground, that the impeachment was done without public participation. So we submit that in this case, there is no evidence that they conducted public participation. The procedure for conducting public participation is contained in Section 91 of the County Government Act. The County Assembly is an institution governed by law. They must conduct public participation in accordance with the mechanics in Section 91 of the County Government Act, where they say the county government shall facilitate the establishment of structures of citizen participation, including information technology, town hall meetings, notice boards, development project sites, avenues, and citizen forum for complete public participation. So they never did any meaningful and qualitative public participation in this particular impeachment. And that is why the Court of Appeal, in the case of Civil Appeal number 17 of and 18 of 2015, County Assembly of Kisumu versus Kisumu County Assembly Services Board, is an authority we submitted to court, and I'm just winding down my submissions as I cite this particular authority. The judges of the Court of Appeal in paragraph 84, 80, up to 90 of this authority are emphatic on three fundamental issues. That one, Kenya is not a dictatorship where county assembly members and senate just determine that we are not governed by the law and we will proceed to undertake impeachment without regard to the court orders. So the Court of Appeal is saying here, the breach of law is a very serious matter. Disregard of the law is a fundamental question that goes to the fundamental workings of the entire democracy. And it says a party who knows of the court order, whether null or valid, regular or irregular, cannot be permitted to disobey it. In this particular case, the respondents know of the court order. As we speak, they know it now. But they are in a continued violation of this court order. It is not up to them, the way they have put in their response, and say that these orders have been overtaken by events. How can they say that, my lady and my lord, that orders have been overtaken by events? The proper approach will have been for them to come and argue this matter in court on merits and set aside the court orders. But they proceeded to impeach and disregarded the court order. So the Court of Appeal, my lady, my lord, is saying, no, you can't do that. It's a taboo to do that. You can't do that because this is not a dictatorship. And then the last point which they say is that really we must follow the law. A governor is elected. Under Article 38 of the Constitution, a governor has a right to hold office. So the removal of process of that particular governor must meet the requisite threshold. It must be strictly in compliance with the law. So in this particular matter, we are submitting that there is no compliance with the orders which were issued by the court. And also on the question of threshold, which is my last argument, the governor was impeached because he has breached the right of the people of Wajir to health. We submit that because of the structure and functioning of the county government, that is not a ground for impeachment. You cannot say that the right of the people have been breached, and therefore you impeach a governor. There is no nexus between the governor and that particular violation, as laid down by the Court of Appeal in the Nyeri case, Nyeri Civil Appeal number 14 of 2015, which this honorable court is entitled to examine and look at. So in my submission, in my final submissions, sorry, it's Civil Appeal number 21 of 2014, Martin Nyaga Wambora versus Speaker of the Senate, where the Court of Appeal said this honorable court has an obligation to determine whether the facts of this particular, of the impeachment, there's a nexus between the governor and the particular violation. So that in this case, the governor was impeached by a principle known as collective responsibility. They're saying that you are CEO, so you are responsible for the mess down there. Never mind that the county assembly is in charge of oversight. The county assembly is in charge of checking the county executive. Number two, I'm just winding up, Senior Counsel. I'm just winding down. That the county assembly My Lord, these are issues which the respondents have put in their response. Am I entitled to quote from their pleadings? If not, then I can end my submission. Because they have the report of the Senate is in the response by the respondents, and I'm just making the argument on threshold because that is one of the issues in the petition. Look at the prayers in the amended petition. It's about threshold. But I was actually winding down my submission.
Questions that he can only argue his case. He cannot be arguing on the basis of what other people have filed. He can only advance the case by the petitioner. So his case is what the petitioner is alleging and is asking to convince the court that make a finding on this averment in the petition, not what other people have filed. No, that's not your case, Mr. Wanyama.
Is there a fees order that I can't? My lady, is there a fees order that I can't quote the documentation filed by the respondents? These are petitions. I can quote documentation filed by the respondents. And I was just winding down. So if you're uncomfortable with that argument, I'm just winding down. I was saying that if you look at the report of the impeachment, and first of all, the prayers in the petition and the report in the impeachment, we have a complaint on nexus, which the Senate itself has said it's a. I will reply. Thank you. I will reply. I think on that issue. I'll take my 10 minutes on that legal question later on. Thank you.
Professor Ojienda, your 30 minutes have been taken. How much of it? By 10 minutes, Professor Ojienda. He has 20 minutes. He has 20 minutes.
Yes, we're not problem.